Hey everybody, welcome to week 5, and that right there is what we're going to be covering this week. That is chapter 3 of the book, which is called Federal Equal Employment Opportunity Laws. That's what the book title for the chapter is. And we're going to talk about that. We're going to talk about affirmative action. So let me just move right into that. Okay, I'm starting this week a little differently. I'm throwing out the discussion question right here, really to prep the groundwork for what I want to talk about in this lecture. So, typical discussion this week. I'd like to give you Thursday night for your initial post and Saturday night for a response to at least one peer. And while I'm on that subject, I want to thank you all for keeping the discussion lively and vital. As I think I've stated, I like to see students comparing notes and impressions of the material with each other because I think that really enhances the learning environment. So, okay, so this is 2018, right? And my question going into this is this topic controversial? Meaning, is equal opportunity, equal employment opportunity controversial? Is affirmative action controversial? And does it seem like it should be controversial? So this chapter, again, has kind of a laundry list of topics. I'm trying to sort some of that out through the way I present this discussion. Hopefully that helps. But my overriding question, and this is the one for the discussion, is where are we as an economy of hiring authorities? So by that I mean really just simplistically imagine our economy with 3 sectors, a for-profit sector or private sector, a public sector, and a nonprofit sector. There are other subsectors, and there's probably more than 3 sectors in our economy. But if we think simplistically of the 3 sectors, and we are an economy of hiring authorities, that means that we are competing with each other for qualified employees, especially now as unemployment rates continue to fall. And in Nebraska, some of you don't live in Nebraska, but Nebraska has one of the lower unemployment rates. So we are competing for employees. So in terms of promoting the broad term equal opportunity, are we there yet? Where are we with that? And if we're not there yet, then what do we have to do to complete this journey? And the bottom paragraph is part of the discussion question on Canvas. And it has some thought-provoking questions, which I want you to keep in the back of your mind as we go through this, which are things like, what benefits does diversity bring to an organization in any sector of this economy? Are race-conscious hiring and admission standards for universities, for example, still necessary? Does race consciousness have unintended consequences? So these are some of the things I want us to think about as you read the chapter, as I go through this discussion here, and as we comment on the discussion board. So before I get into that, just a couple of housekeeping reminders. Your human resources issue paper, that is your term paper, the proposal is due this week. So please look at Canvas for that and the syllabus to see what I have asked you to do. Please do email me or call me if you have questions on that, and I will more than happily discuss that with you. During week 5, not this week, but the week after, there is not a discussion, but there is going to be the Unit 1 summary. So that's just one to keep in mind. Okay, let me move on here. Okay, so equal employment opportunity, right? So we have been talking, and the author, Joan Pines, the author of the book, talks about the idea that human resources management should be strategic in its orientation. So if we're talking about strategic human resources management, then is compliance with existing law a strategic function? Or alternatively, is compliance with existing law simply a legalistic compliance function. I know I used the word compliance twice, but so that kind of begs the question of, is HR strategic, a strategic part of the direction your organization is going, or is it an advisor, in this case, a legalistic compliance advisor, that advises you on this plethora of laws with which you have to comply? And so all that begs kind of a further question, which is it within an organization's strategic interest to move beyond simple compliance with law to advocacy, really active advocacy of diversity in their workplace and writ large in the large workplace of our society? So underpinning all this is my view of why equal employment opportunity laws have been necessitated. So this last bullet is something I am saying. This is my quote if you want to quote me. Equal employment opportunity and affirmative action are underpinned by a history of racial and gender discrimination in the United States. Differing interpretations of the history of the United States, lingering cultural artifacts, institutional discrimination, and differing views on whether adequate remediation has or has not been offered. But the question is now, where are we going? So you can take issue with some of the assertions that I make in there. I would have a difficult time with the assertion that the United States does not have a history of racial and gender discrimination. I think it's pretty clear. We exercised racial-based chattel slavery in this country for 300 years. And in fact, the Civil War was fought primarily over the issue of whether or not slavery should be expanded, continue to be expanded into territories in the United States. And so it's difficult to say that the United States doesn't have a history of institutional discrimination. Post-Civil War, as a matter of fact, is when really institutional discrimination really took root, and particularly in the southern states, but in other places as well. State laws, so-called Jim Crow laws, were instituted post-Reconstruction really to ensure that African Americans, former slaves, and their descendants could not vote, would have a hard time getting employment, would have a hard time buying property and houses in certain areas. And all of this was enforced through really the scaffolding of, if you will, of the state. And I mean the particular states and the United States. And so from that, we have lingering cultural artifacts, which we're still arguing about. For example, the meaning of the Civil War in the United States. We continually argue about that, don't we? We can see this in the news all the time. And really all of this leads to an idea that, a question really, have we exercised adequate remediation, right? It is a simple fact, for example, moving away from race, but it's still a fact that women overall in the economy earn less than men for equal jobs. That's not universally true, but as a general premise, it's still true. So have we actually achieved the remediation that normatively should have been done, that people argue should have been done? But the question is, in view of that, because we can't keep dwelling in the past, can we? I mean, I would assume it's everyone's hope that we make progress as a society. The question is, where are we going? So if, again, we're thinking of strategic human resources management, we can think of many of these laws as part of the environment, right? So all organizations, public, nonprofit, and private for-profit, have to comply with equal employment opportunity laws. And these laws have some difficult parts that might seem to contradict each other. But just the fact that that environment exists is a good enough reason to have a human resources function in an organization of sufficient size so that you can ensure that compliance is rendered, right? It is also a fact that public employees enjoy some constitutional protections that aren't available to nonprofit or for-profit employees. And it's also true in that environment that states and local laws might supplement all the laws that I'm about to talk about with regard to the federal government. So, for example, Omaha has a non-discrimination ordinance that prohibits discrimination for government city hiring, as well as companies over a certain size, based on sexual orientation or gender identity. Lincoln doesn't. The state of Nebraska doesn't. So there's an environment where laws, and Omaha, by the way, probably its law is not nearly as progressive, if you like that term, as many other cities. But the point is that in various environments, you're going to find laws that support each other and perhaps contradict each other. So let's talk about some terms that are in this chapter, and this is talked about later in the chapter, but these are important. So what civil rights laws have done, basically, in a legal sense, is created a protected class of employees and a non-protected class of employees working in the same places. So what this means is that under this list of laws, it is against the law to violate, to discriminate in hiring or practice, HR practice, against protected class employees. So that brings into question, what do we mean by that? So there's two things from the chapter that are really important: disparate treatment and disparate impact. So disparate treatment actually is simply when an employer intentionally treats an employee of a protected class differently. So in hiring, the example the book gives is asking a woman, hey, what's your family status? Do you plan on having more kids? What does your husband do? Whereas you wouldn't ask a man those same questions. That's disparate treatment. Disparate impact is when an employer's policy or practice, whether it's neutral on its face or in its application, has a negative effect on the employment opportunities of protected class individuals. So police departments, fire departments do their hiring practices, which include a battery of intellectual, physical, psychological testing. Do they end up discriminating against protected class people? And if so, what remediation actions do they need to take? The point is that both disparate treatment and disparate impact are violations of the law, and that's what needs to be kept in mind. So more terms. Equal employment opportunity, which is really the title of the chapter, is simply this from page 93. Equal employment opportunity requires employers not to discriminate in the administration and execution of human resources management practices such as recruitment, selection, promotions, training, compensation, career development, discipline, and labor management relations. The point is, it's not just hiring practices. It is all the practices that encompass human resources management. So employers are not permitted to violate those laws. Affirmative action, on the other hand, is a set of specific and results-oriented procedures to which the contractor commits itself to apply in a good faith effort. So that's from an executive order signed way back when by President Johnson. And in that EO, it talks about the contractor, because really this was applied to contractors doing business with the federal government. But now that's expanded. The term affirmative is important to keep in mind, because what it means is the organization is not passive. It is affirmatively taking action. That's where affirmative action comes from. Taking active steps to make sure employees are not treated differently. Another term, which we're going to get to later on, and this is important in government employment, civil service employees are generally more protected than what are called at-will employees. So a civil service employee is a person hired by a government. It started out at the federal level, but we usually use that term for any level of government. A civil service employee is hired based on qualifications, based on perhaps testing, an interview process, and as a result, once hired, that employee gains some protections from arbitrary discipline and arbitrary firing, for example. It doesn't mean you can't fire a civil service employee who is not doing their job, a popular myth. You can. It may be harder, but you certainly can do it. At-will employees in government typically are people that are hired often as political appointees. So for example, when the mayor of Omaha, a new mayor of Omaha is elected, that mayor appoints several positions. One of those is the budget director. So the budget director is hired directly by the mayor. That's in the city charter. But the mayor can also fire that budget director without any cause, really. So at-will employees don't have as many protection rights. Okay, so I want to dive into affirmative action just really quick for the next 3 slides or so. So complying with equal employment opportunity laws is a legal duty. So if the law says that for example, federal agencies, state governments, city governments, local governments, private for-profit organizations with more than 15 employees, for example, have to comply with this law, they have to comply with this law. It's not a choice. It's a legal duty. Affirmative action, on the other hand, can be voluntary or involuntary. So here's a couple more executive orders signed by President Johnson. So affirmative action applies to all federal agencies, contractors, and subcontractors, including the facilities of the agency holding the contract. So what that really means is, at the time it was written, and now it's practiced pretty much, but it's probably violated. I would not, I wouldn't be shocked to see it violated. If you have a NASA facility, for example, in the 1960s on the Apollo program, those contractors and subcontractors were supposed to comply with affirmative action processes because they're working for the federal government and they had a contract for more than $50,000. That was really what those executive orders said and did. That's where affirmative action really had its beginnings. So here's 4 bullets here. I just want to highlight a couple things from each bullet. Again, the first bullet, equal employment opportunity is a policy of non-discrimination, but affirmative action requires employers to actually analyze their workforces. You could say strategically analyze their workforces and develop plans of action to recruit, select, train, and promote members of protected classes, right? So we see this actually happening. We do see, for example, police departments, fire departments, other agencies like that who make conscious efforts to hire minorities and hire women. The fact of the matter is there are more female police officers now. In many departments, there are more African American police officers and more Hispanic police officers. There are many departments that aren't there yet, but the point is that those are a result of affirmative action. The idea of affirmative action, when initiated with the federal government, was to promote a more diverse workforce as sort of a beneficial end in itself. So the Supreme Court has upheld the use of court-ordered affirmative action programs designed to eliminate egregious past discrimination. So that's really remediation for past actions. So affirmative action has that intent as well. And the Supreme Court has not upheld the use of racial quotas, and race serves as the only criterion for admission to universities and advanced graduate programs, or when race is used to abrogate seniority systems and layoffs. Okay, so a very popular myth is that all affirmative action is quotas and nothing more than quotas. That really isn't the case. So racial quotas in and of themselves are not allowed in affirmative action programs, and some of the readings that I assigned you will talk to that. So some of this is a repeat. What I want you to look at is the last bullet there. Involuntary affirmative action is permitted under the Civil Rights Act of 1964. What does that mean? That means that an employer may be ordered by a court to practice affirmative action, and there's three kinds of orders that a court can give. One is a conciliation agreement, which is where an employer acknowledges discriminatory practices and agrees to meet compliance. Second is a consent decree, which is, again, an agreement between an employer and some compliance agency with oversight, though. So a consent decree always has oversight by a court, typically, or a special master, or someone who has been appointed to enforce that consent decree. And finally, there's a court order when, just very simply, past conciliation and mediation, the court actually takes an agency takes an employer to court, and the court actually just orders the employer to apply remedies, and specific remedies that they have to comply with. Okay, so boom, this slide is entitled "Take a Coffee Break." So do that, please. I'm 21 minutes into this. I'm going to talk for a little while longer. I do want you to take a break. While you take the break, here's what I want you to do. Or actually, after you get your cup of coffee, take your break and pause this video. I want you to come back and look at page 83 and 84 of the text. There's a list of 14 separate pieces of legislation from 1866 all the way through 2008. So 14 different laws passed by Congress. They don't always necessarily align with each other, but what they do in general is establish various protected classes of employee. Second thing I want you to do before you turn the video back on is look at the other sources I provided you this week on Canvas. So what those sources are talking about really is affirmative action in education in general. That's what it's talking about. Harvard University is being sued right now, and that's part of those documents. Harvard University is being sued right now because the accusation is that their race-conscious admissions program has either intentionally or unintentionally discriminated against Asian students. So really what that becomes is perhaps either an intended action by Harvard or an unintended consequence of race-based, race-conscious recruitment practices in higher education. So when you come back from the coffee break and you do those things, what's coming up next in the lecture is a long laundry list of laws that are part of the list from pages 83 and 84. Here's what I want you to think about when I'm going through this, the rest of this lecture, is think about who is the protected class in each law, and so then who is the non-protected class. Think about whether in general you think compliance has occurred or whether affirmative action would be necessary, and then finally think about those who must comply. Okay, so take that coffee break. Please do the things I asked you to do. You know, walk your dog, actually do whatever you want, then come back for the rest of this lecture. Okay, I hope you had a nice break because I'm going to go through some of these laws and just highlight things that really are important in the spirit of the law, and I think that's what's really important. So what's surprising to a lot of people are first civil rights laws, the Civil Rights Acts of 1866 and 1871. 1866 and 1871, so immediate post-Civil War. These actually partially implement what are called the Civil War Amendments, which are the 13th, 14th, and 15th Amendments. The 13th Amendment outlawed slavery. What the Civil Rights Act of 1866 did, what it tried to do, was prohibit racial discrimination in the making and enforcement of contracts. So the protected class in this case were really Black Americans, most of whom were former slaves, and their children. So 1866. 1871 really implemented the 14th Amendment, which we quote a lot for its due process clause. The 14th Amendment and the 5th Amendment, by the way, actually work hand in hand. The 5th Amendment and the 14th Amendment both prohibit actions without due process of law, but the 5th Amendment really only applies to the federal government, while the 14th Amendment applies to states. So based on that, what the Civil Rights Act of 1871 did was prohibit deprivation of equal employment to blacks under state laws. So it applied to both state and local governments. So again, a protected class was established, and the non-protected class really were the white Americans. So in both these instances, the agencies that had to comply were the federal government and state and local governments. Okay, let's jump all the way up to 1964. Why are we jumping up to 1964? Because those two acts, really by and large, were institutionally ignored in many cases. So part of President Johnson's so-called Great Society program, one of the acts was the Civil Rights Act. Title VII of the Civil Rights Act is what is referred to most of the time, which prohibits discrimination based on race, color, religion, sex, or national origin, and that applies basically to everybody. So any employer with 15 or more employees, except with those exceptions, right? And they're important exceptions. Private clubs, religious organizations, and places of employment connected to a native reservation. So in 1972, Congress applied this act to state and local governments as well as educational institutions in the United States. And it created the Equal Employment Opportunity Commission to investigate such complaints, and then came up with this term, Bonafide Occupational Qualification Exceptions, BFOQs, which are often employed. So that's a good term to keep in mind as well. Okay, so here's more lists of anti-discrimination laws. There are laws addressing religious discriminations. What this basically says is that there are institutions, for example, education institutions owned, supported, controlled, or managed by religious organizations that teach within a specific religious context. They are exempt from the law. So, for example, there's a case cited in the book where an organization of the Latter-day Saints fired a janitor from his job because he said he was not a practicing Mormon, and the court held for the institution. Now, think about this in light of some of the things we argue about currently, so-called religious freedom and religious discrimination. This is actually a hot button issue. There are organizations that are specifically religious in nature and say we need to be able to be free to hire people who accept our doctrinal stance. And so whether that person is black or white or Asian or male or female or transgender, we need the right to actually apply our religious doctrine to hiring. And the court has held many times in favor of religious organizations under this law. Then there's age discrimination. So basically what we know about age discrimination is that it's illegal. But, that doesn't mean that age discrimination does not take place, and probably takes place with impunity. So, when you read comments that hiring authorities make and say, you interviewed great, but we're looking for someone with more energy. Well, that's probably code for we're looking for someone who just graduated from college that we can pay less to. I mean, I don't want to be cynical, but age discrimination does exist, but it is illegal under the Age Discrimination in Employment Act. Now, this is an area where the BFOQ can apply. For example, an employer can prove that people of a certain age are probably unable to meet the minimum requirements of the job, especially if they require a lot of physical activity. So that may be a case where a BFOQ might actually be valid. So the Americans with Disability Act, which is actually a fairly well-known law for other reasons, especially access to buildings, but this actually applies in hiring as well. Again, organizations with 15 or more employees and all these government organizations, right? So the point of the ADA is that an individual has to be able to perform the essential functions of the position with or without accommodations, that employers must provide reasonable accommodations that don't place an undue hardship on the organizations. This is why, for example, the university offers reasonable accommodations to students with a bona fide disability. That's why we have an office on campus that actually interviews the student to understand the scope of that disability and then prescribes an accommodation to the instructor, right? So that is the point of that act. And so in this sense, then, of course, the protected class of employee is the person with the disability. This is one that people don't think about as a civil rights issue, but it is. So the last time we had a comprehensive immigration law was 1986, really, during the Reagan administration. We argue about immigration all the time. It's been 30 plus years since we've had a new law. But basically, this is the basis of the I-9 form, the employment verification form, which you've all filled out, I'm pretty sure. So basically what it says is that an employer can't discriminate based on an individual's citizenship or immigration status unless it's required by law. So I mean, under this law, what this means is that a person has to be qualified to work in the United States. That means that you have to be a so-called green card holder, or you have to have some kind of visa that allows you to work in the United States, or you have to be a naturalized or born citizen of the United States, right? But in all these cases, you have to be able to document that. So, so what it's saying is that this law, what this law does, among other things, is hold up the idea that discrimination against a citizen is actually illegal, or against an authorized worker is actually illegal. So that's an interesting construct of this law. So the Civil Rights Act of 1991 talked about harassment, and it amended several laws, and basically what it was trying to do was strengthen anti-discrimination laws that people felt had been weakened by several Supreme Court decisions. And one of the things it did was trying to eliminate the so-called glass ceiling, barriers to women in employment. Whether it did that or not, that's a good question. The Family and Medical Leave Act of 1993 actually applies to many employers, and people actually can take advantage of it. It is unpaid leave in the United States, of 12 weeks of unpaid job protected leave, and that is the key of the Family and Medical Leave Act, that it is unpaid and job protected. Many employers were opposed to that aspect of it. that it's job protected leave. However, in this case, the protected class are people who really have family emergencies, medical emergencies, which require them to be away from work. And so basically, like all the other laws, it carries with it a burden of proof that the protected class must provide to the employer. This actually had to do with people with a physical or mental disability. So what this tried to do is actually define what physical and mental disabilities were, and on one hand, increase employment for people with physical and mental disabilities. On the other hand, try to create some logical rationale for hiring or not hiring persons with mental or physical disabilities. These are a couple that applied to the armed forces: the Vietnam Era Veterans Readjustment Act, and the Uniformed Services Employment and Reemployments Act of 1994. You often hear veterans' preferences. Again, veterans do have a preference in some hiring, but like many other of these acts, the complaint that this automatically guarantees that an unqualified veteran will get a job before qualified me turn out to be typically unfounded. And finally, the Genetic Discrimination Act. So this is newer law because of our technology, because we can find out about our not only our genealogy, but we can find out about perhaps genetic tendencies towards genetic conditions and diseases that we might have. The basic point of this law is that an employer is not supposed to use that against you. Is not supposed to use genetic tests to say, oh, you are subject to a certain type of cancer, or early onset dementia, or many other conditions, therefore I won't hire you. That's what this law purported to protect. The Pregnancy Discrimination Act of 1978 purported to protect women, discrimination against women on the basis of pregnancy, childbirth, or related medical conditions. So it also said that employers couldn't keep engaging in the practice, which were common really up to this time, of automatically firing a woman when she had a baby. It was common practice, and that's what this law tried to prevent. So at this point, you could probably take another pause. I'm just going to cover a couple other things. One is the constitutional rights section of this chapter. So actually, what this last part of the chapter really talks about, and I'd like you to read it thoroughly, is this idea that it has been a bit of a struggle for government employees to gain some of their constitutional rights under the Constitution, right? So to gain rights of expression under the First Amendment and freedom of association, equal protection of the law under the Fourth and Fifth Amendments, privacy rights under the Fourth Amendments, due process rights under the Fifth and 14th Amendments, and limitations on political participation. So I think there's maybe one or two students in the class that are very well versed in the Hatch Act, for example. What the Hatch Act says is that government employees at the federal level can't be openly involved in the workplace in elective politics, and there are what are called mini Hatch Acts at state levels. Well, so there are various provisions, but the point of the Hatch Act was actually to protect the employer and also to protect the employee, I should say, and to protect the employer. So the point of the Hatch Act really was to prevent unscrupulous supervisors in the public sector from telling employees they had to do things like campaign for a certain person for Senate or Congress, and in the case of so-called mini hatch acts, campaign for a certain person for mayor or governor. So to protect the employee, but also to prohibit the employee from using the workplace, if you will, as a platform for electoral politics. So more protections for employees have arisen over the years. One is whistleblower protection, which the book talks about. It's curious. Right now, we have supposedly an anonymous senior member of the current presidential administration who wrote an op-ed in the New York Times. I'm sure you heard of this. That person wouldn't be protected by whistleblower protection. That person, whoever that person is an at-will employee and probably wouldn't be protected by whistleblower protections. But whistleblower protections talked about in the book are designed to protect employees who detect wrongdoing in the workplace. So, for example, someone who works for the Defense Logistics Agency who notes that government contracts are being offered to people with political connections to certain politicians. If that employee documents that and testifies before Congress or someone else, they have rights under whistleblower protection laws to retain their job. At-will employees, and I told you we'd eventually get to this, at-will employees really are people that can be fired for pretty much any reason, except they also have rights, and you can read about those on page 104. Interestingly, what the courts have found for at-will employees is that if the workplace has things like employee manuals that talk about procedures for firing an employee, if there are implied contract exceptions, then that employee has certain rights in the at-will environment. Now, in public administration, interestingly enough, one of the most popular at-will employee jobs is city manager or city administrator. City managers and city administrators, last time I saw the number from ICMA, I think, was the average tenure of a city manager in a small city or any city in the United States was about 5 years. So the advice that the kind of anecdotal advice that is given to many city managers is that you want to be thinking about negotiating an exit package even while you're still on the job, because city managers are a classic example of an at-will employee that can be relieved of duty by the city council for reasons that they don't have to explain to people. And that is what differentiates civil service employees from at-will employees. So boom, I told you I'd circle all the way back to this. I'm 44 minutes into this lecture. That's why I gave you a coffee break. So shame on you if you didn't take it. So after you read the chapter, after you read the supplemental literature I gave you, which has to do with affirmative action in education, and after you've thought about this lecture, here's what I want you to think about. And again, the theme of our entire course is strategic human resources management, right? We are trying to make our organizations more strategic, and we are trying to make human resources part of that kind of strategic thinking. So here's the question again. Where are we, the big we, where are we as an economy of hiring authorities in terms of promoting the broad term equal opportunity? That is, are we there yet? If we are not there yet, what must we do to complete the journey? So what I'd like you to do on this question is think a little bit philosophically, and I offer those questions at the end to help you in your thinking. You don't have to answer those several questions in the last paragraph there. Those are really to spur your thinking. But I'd really like you to talk about equal employment opportunity and perhaps affirmative action in an effort for all of us to understand from each other whether we think we are there yet in the economy of hiring authorities. And if we're not, how do we have to complete the journey? So that's it for this week in terms of the discussion. I'm really looking forward to your responses. And I think this will be an interesting discussion. Thanks.